Hey guys, welcome to the weekly Docket. This week we'll look at updates from Idaho, Wisconsin, and South Carolina. Let's start in Idaho with the case of Bryan Kohberger. He's accused of the brutal slayings by knife of 4 University of Idaho students in their homes. While the case remains in litigation over the judge's gag order, some information does make its way out. Pennsylvania authorities released this information on the raid the night they arrested Mr. Kohberger, saying he was found awake, and remember this is at 1:30 in the morning. He was found awake in the kitchen area, dressed in shorts and a shirt, and wearing latex medical type gloves, and apparently was taking his personal trash and putting it into separate Ziploc baggies. He had also been seen earlier engaged in his apparently favorite hobby of cleaning, also putting trash in his neighbor's trash can. With a guy so focused on trash and being clean, the one thing he didn't do was refrain from littering at the murder scene when he left the sheath for his knife with his DNA there. So as I mentioned, the case remains in litigation over the gag order. I don't suspect there'll be major changes to that. Who knows? But what did happen is defense counsel requested an additional death penalty qualified counsel to be appointed, and the court agreed and is going to appoint another person with those certifications. I don't think the prosecution has announced the death penalty yet, but this case would be eligible for it. Let's stay in Idaho and look at the Lori Vallow case, still slated for trial on April 3rd. The judge has said this case is not going to be broadcast, and also entered an order that won't please the media. Note, there will be no priority or designated seating for media, and no one may reserve seats except through the reservation system. I think that's like a daily thing or something. So the media's got to hate that, I'm sure. Another issue besides the discovery fights I noticed is the defendant's Vallow's counsel's argument against the death penalty. I've noted before in Idaho, which is true in some other cases, that they can't get the combination of drugs that they normally use to execute someone, so they don't execute the people because they don't have another method. So here her counsel notes the state of Idaho doesn't have chemicals to kill people on death row. They've tried to kill somebody for 35 years, haven't managed to do it because they can't get the drugs for killing and therefore can't execute people. So they're saying just take the death penalty off the table. And you see that argument in the states with people against the death penalty saying if you can't get the drugs and you just leave people forever on death row, that is in and of itself a cruel and unusual punishment. I don't know that that's succeeded anywhere yet, but this is a similar argument that, look, it's a futility to go for the death penalty when the government doesn't have the means to fulfill it. So we'll see what the court says about that. Let's head to Wisconsin and check in on the Zachariah Anderson case, which last week we labeled the world's friendliest murder case. As predicted, that did not last long. The trial descended into mutual accusations of misconduct. The DAs had been present when a witness allegedly changed her story, and defense wants the DA removed from the case. The DA said, hey, the defense is just playing games and pulling stunts.
I don't know what we're discussing that was not discussed a couple of weeks ago before this court.
Well, what we're discussing is the only stunt here is Mr. Gravely misrepresenting to this court what actually happened. The fact is that he went out and met with this witness months before trial, didn't tell us anything about it, and then made it a prominent part of his opening.
The judge considered the arguments and warned the DA, in fact, he might have a problem being able to continue to argue this case if his credibility became an issue as a witness. The judge ordered the DA out of the room when the witness was examined and had the other DA do the questioning.
Okay, the remedy is to have him leave this case and have them, if they want to call this witness, have them then call the witness, and then we'll call Mr. Gravely after we cross-examine her about her interactions with him, and then we'll get him on the record about what his interactions with her was.
It comes into issue, or if there's an inconsistency of any kind between your recollection of events and that of the witness here, that I think you're probably going to be precluded from arguing anything about the case.
The judge, having made his mind up, finally had to condense the nonsense and tell the parties, let's just stop all this and let's get this trial moving again.
I just wanted that to be clear, that this is not something that the defense cooked up. This isn't a stunt.
I don't want to hear any more. There have been jibes periodically throughout the trial, and I've had as much as I want to hear.
The trial resumed, and at least so far this week, the DA has been back in the room handling the case, so all's well that ends well, and maybe this case will someday make its way to the jury. Now down to South Carolina Low Country for the Murdaugh trial. The jury reached a fairly quick verdict, convicting Murdaugh of murdering his wife and son. The kennel lie was, of course, critical to the case, but as promised, Harpootlian has filed a notice of appeal which begins the appeal process. It will be a while before briefs are filed and the actual arguments are known, but of course, just a couple of those include the financial evidence and the scope of expert testimony. You can expect them to appeal on that. Many non-thinkers upset with the verdict have given over to baseless criticism of the jury, making accusations without evidence regarding the fix being in, jury misconduct, how the jurors look, and they didn't think about it long enough, or whatever. It's an interesting thing to do when your chief complaint is, purportedly, allegations without evidence. But of course, a lot of it is just recreational outrage of people voicing opinions without doing the tiniest bit of research. Let's take a look at that "they didn't think about it long enough" canard. If only they thought about it longer, I could accept their verdict. Well, Murdaugh's associate Russell Lafitte, who was CEO of Palmetto State Bank, he was convicted in federal court for various felonies associated with Murdaugh's activities and what he did as well. He asked the judge to throw out the guilty verdicts. During the deliberations process, which was highly unusual, 2 jurors were replaced by the judge with alternates during deliberations. The horror. Social media lawyers, assemble. But the ace card was thrown that when the new jurors came in, they didn't think about it long enough. The judge dismissed that argument, saying this: defendant's late objection to the court's charge for the jury to begin their deliberations again is a backdoor challenge to the length of time deliberations after the alternate jurors were placed. The difficulty for defendant is there is no minimum time required for jury deliberations, and any inquiry into the details of jury deliberation is strictly prohibited. It cites cases saying a jury is not required to deliberate for any set length of time. Brief deliberations by itself doesn't show the jury failed in any way. If the evidence is sufficient to support the verdict, the length of time the jury deliberates is immaterial. Now, that's federal court, not state court, but social media lawyers should take notice of the attitude of the judiciary toward just casually throwing out jury verdicts or second-guessing them. At any rate, onward and upward for the defense as they start the appeal process. I wondered how Murdaugh funded this, and apparently he cleaned out his 401k for the defense, so go ahead and burn it up. As the appeal process slowly grinds along, Murdaugh faces around 100 other charges for his crimes and investigations into suspicious deaths surrounding his family. So a successful appeal, whatever the odds, could mean a new trial. Congrats, you get to try to lie better the second time. But sadly, by then, Murdaugh, you'll be under the heavy yoke of sentences for crimes perpetrated against so many members of your community. You're going to be staying in prison, bro. It's over. Is it too late to start a real killer search smokescreen like OJ? Harpootlian seemed to indicate no appetite for this in his interview after the trial. He did say, though, they'd appeal all the way to the Supreme Court. That's a crowd pleaser statement, all right, but it supposes you lose at every lower state and federal court available to hear your case. That sounds good, doesn't it? And while it connotes a lofty aspiration, Supreme Court appeals on issues like this occur only if the Supreme Court agrees to hear the case. And the success rate, when you ask that percentage, is somewhere in the very low single digits. Imagine thinking Justices Thomas and Sotomayor are up there waiting to push everything else aside and come together to hear some evidence issue for a low country case for a corrupt lawyer who by then will have lost at trial and every appellate court he's been to. Yeah, it happens. And people win the lottery, too. Good luck, you corrupt, violent loser. Well, that's it for this week. Thanks. Bye.